Okay, good evening and welcome to Planning for Senior Life. I'm Lorraine Moffa, Programming Coordinator for Loudoun County Public Library and your host today. Please feel free to send your comments and questions to me during the program by using the chat feature. I can then relay them to our speakers either during or after the program. It's my pleasure to introduce Shea Newton and Pam Reynolds. Shea is a certified financial planner and a retirement income certified professional who helps individuals make educated financial decisions. Pam Reynolds is a certified aging life care manager and professional gerontologist who is passionate about the well-being of aging adults. Before joining the law firm of Joshua E. Hummer, she spent over 15 years as an owner and operator in the senior healthcare industry. In her role as an estate and elder planning specialist, she calls upon that experience and serves as an advocate and guide for clients as they navigate all aspects of aging well. Shea and Pam are members of Planning for Senior Life, the Loudoun County chapter. Planning for Senior Life's mission is to provide individuals transitioning to their senior years with professional services, tools, and education customized to meet their unique desires and needs as they age. We're really grateful for you being here today, Pam and Shea. Welcome.
Thank you so much. We're happy to be here.
Thank you. All right, so let's get started. So what is Planning for Senior Life? So as you heard Lorraine say, our mission is to provide individuals transitioning to their senior years with professional services, tools, and education customized to meet their unique needs and desires as they age. So all of our members are experts in their respective industry who are professionally vetted and committed to providing the highest level of service to our clients. We focus on 5 pillars. Those 5 pillars are legal, housing, financial, health, and lifestyle.
So why plan? We plan for so many things in life, but one stage that's often left up to happenstance is aging. And seniors want to be independent, but often fail to take the necessary actions to ensure that their independence or plans for situation in which they need to rely on others are taken care of. The adult children are often in denial that their parents need help, or simply are too busy with the hustle bustle of daily life to see what is happening until a crisis hits. So proactive planning is the key to aging well. You need a plan that is designed to give you confidence and peace of mind for the future. So today we're going to give you an idea to figure out where to start.
All right, so we have some important dates for you. So starting at age 50, there are lots of different things that can happen and that you can take advantage of and things that you need to know. So at age 50, you're eligible to make catch-up contributions to your retirement plans. So that means IRAs, Roth IRAs, you can contribute $7,000 versus $6,000 for this year. And for your workplace retirement plans, 401ks, you're eligible to do $26,000 up from $19,500. At age 55, you're eligible to make catch-up contributions to your health savings accounts, which is $1,000 to your plan. And you're also eligible for penalty exceptions for certain withdrawals from retirement accounts. Then at age 59 and a half, you're eligible to take money out of your retirement plans without penalty. At age 60, you can claim Social Security survivor benefits as a widow or widower. At age 62, you're eligible to claim your own Social Security at a reduced rate. And 64 and 9 months is the starting window that you can sign up for Medicare. And at age 65, you're eligible for Medicare coverage. And you're also eligible for non-medical withdrawals from your health savings account without a penalty. Age 66 is full retirement age for Social Security for those born between 1943 and 1954. Age 67 is full retirement age for those born 1960 or later. And if you were born between 1955 and 59. There's a graduated scale, 66, 2 months, 4 months, etc., until you get up to 1960. Age 70 is the maximum Social Security benefit. There's no point in waiting to claim after age 70. Age 70 and a half, you're eligible to make qualified charitable distributions. So what does that mean? Currently, for a married couple filing jointly, the standard deduction is $27,800. So your itemized deductions, which is where your charitable contributions are on your tax return, have to be more than that $27,800. For a qualified charitable distribution after age 70 and a half, you can make a contribution directly to the charity from your IRA, and you'll never pick it up in income. So you're not paying income taxes on it, and you don't have to jump that standard deduction hurdle either. Age 72, you have to start taking required minimum distributions from your retirement accounts. So for all the money that you were able to put away tax-free and not have to pay any taxes on it until later, the government wants their money. They need their tax revenue. So you're going to start having to withdraw that at age 72. And if you miss your required minimum distribution in any year, there's a 50% penalty, 50. So not only do you have to take the money out, pay the income taxes, there's also a 50% penalty on that amount that you were supposed to take out. So you don't want to miss those. All right, so let's dive a little bit deeper into Medicare and Social Security. So as I said before, you can start to sign up for Medicare at 64 and 9 months. So there's a 7-month window to sign up for Medicare. 3 months before your eligibility date, the month of your eligibility date, and 3 months after. So your eligibility date is either age 65, or if you're working for a company that has more than 20 employees and you have creditable coverage, which you'd have to confirm with them, then you can wait until you retire. You get that same 7-month window. So what's really important to know about the window is that if you miss this window, then you're going to have a penalty on your Part B and your Part D. Okay, and that penalty lasts forever. So it will be added on to your monthly premium forever. So you don't want to miss that. And the penalty for Part B is 10% for each 12-month period that you were eligible and didn't sign up. And again, that's forever. And Part D will also have a late enrollment penalty. Okay, another important thing that people need to realize about Medicare is that there's no out-of-pocket limit. So Medicare generally covers 80%, and this is why we recommend getting supplemental policies to cover the other 20%, especially since there's no limit on what your out-of-pocket costs could be. Okay, and then Part D is your drug plan. So every year there's an open window to rebid your drug plan, and it's pretty easy. You just log on to the Medicare site, have your list of drugs, and I recommend doing this every year because the plans change every year, and I've had people save $100 a month just by putting in their medications and seeing a different plan that's available and switching over. And do it every year because they do change every year. Okay, Social Security, it's important to know the rules because at 62, you can apply for your own benefit. So depending on what your full retirement age is, whether it's 66 or all the way up to 67, you'll get 70 to 75% of your full retirement amount. So this is a permanent reduction in your full retirement benefit. So And you're also subject to the earnings test if you take Social Security before your full retirement age. So if you're earning money while receiving benefits, and you claim before full retirement age, you're subject to the earnings test and may have some of the benefits withheld. But once you're full retirement age, then you can earn as much as you want. You can still be working and take your benefit at full retirement age, and there's no penalty. And you may have heard me say earlier, age 70 is the last age that you should wait to claim your benefit, because there's no benefit to waiting after that. Well, what I mean by that is from full retirement age up to age 70, you can earn an 8% credit to your benefit plus the COLAs in between there for delaying your benefit. So if your full retirement age is 66 and you wait till age 70, that's a 32% bump plus the COLAs. So that's pretty significant. And if you're married, we like to maximize at least one of the benefits, because when one spouse dies, the survivor gets to claim the higher of the two benefits. So that's why I really like to maximize one, so that you've got a good solid benefit when one of you passes away. And keep in mind that this is someone else sending you money. This is not, an asset that you're drawing income on, and it has a cost of living adjustment. So it's really important that you know the rules and make the best decision that you can for your situation. So this is a very high level overview of Medicare and Social Security and what to be on the lookout when making those financial decisions. So now we're going to shift over to Pam to talk about the legal components in planning for aging years and legacy.
Thank you, Shea. So when we're talking about estate planning and elder law, they go hand in hand. However, we want to bridge the gap. What happens too often is that estate planning is done in a silo and focuses on the documents and nothing else. So we need to consider a lot more in terms of elder planning than is traditionally being done. We need to do both, and with more holistic estate and elder planning, we are trying to accomplish two things. The first is protecting and caring for you while you are alive and giving you the highest quality of life possible, and then protecting and caring for your loved ones after you're gone. And too often, the first is glossed over, and people are poorly prepared for their aging years, resulting in negative outcomes and stress and burden on the adult children. So starting with estate planning, and forgive me, I'll have to make the slides go too. What we're doing with estate planning is planning to transfer your assets after you pass. And so there are three tools primarily that you can use to do this. They are wills, trusts, and beneficiary designations. And most people need a combination of two or more of those to create a cohesive plan that accomplishes their goals. And with this planning, we focus on who and what is most important to you. And the common themes that people are most concerned about when it comes to their estate planning are protecting and providing for their loved ones and making sure that your money doesn't cause unnecessary problems for them. Avoiding conflicts. Money can make people react in unpleasant and unexpected ways, unfortunately. So we design our plans to avoid creating any unnecessary conflicts. Leaving a legacy, and this can be within your family or even in a charitable way. And Shea had mentioned charitable contributions earlier. You can also use your estate to make an impact on people, your community, and the future. Preserving special memories, using non-legal documents to pass along your memories, values, and beliefs, and what is most important to you that is non-tangible, and also the memories that are tied to tangible items as well. And also easing burdens on your family related to your passing. So that's a very stressful time for your loved ones. And so many people wish to minimize probate challenges and costs, and this is done with a combination of both legal and non-legal documents and strategies. So next, when we talk about elder planning and elder law, we are planning for incapacity. That is what that is referring to. And we need to do this for many reasons. We want to avoid and prevent exploitation, fraud, and abuse. We want to ensure that you're ready for potential long-term care needs. We want to avoid unfavorable aging outcomes, keep you in control, and give yourself choices later in life. Money gives us more choices. We gather assets and we have money as a tool. It does give us more choices, but good planning gives us choices too, even if we do have limited assets. So what are some of the things you can do to plan well? First is choosing your agents carefully. So what I'm talking about here from a document standpoint, at least here in Virginia, is the advanced medical directive and the financial power of attorney. And these documents allow someone to step in and act for you and make decisions on your behalf when you cannot. And doing this helps you avoid getting stuck in situations where you are incapacitated and cannot access the funds you need, or end up in care situations that are drug out longer than you would have liked. And so it's crucial to put careful thought into choosing your agents. They should be people whom you trust, who have ethics, and will do the right thing for you first and foremost. And so you're putting them in these positions where they will have the legal authority to carry out your wishes. And that avoids the situation where you become incapacitated and someone ends up having to actually petition the court to get control. That's called guardianship. It's a much more difficult, lengthy, and expensive process. So doing this ahead of time is relatively simple from a legal document standpoint. It's not simple from a preparation standpoint. And so I'll elaborate on that a bit. First, what you really want to do once you've chosen these agents is you want to have the conversations with them. You want to empower your decision makers with knowledge. It's important to document your wishes, but you also have to discuss them. So don't just put the documents in a box after you've drafted them and expect your agents to know what they're doing when the time comes. So you want to let them know what your preferences are, what types of care you wouldn't want to receive, where you want to go. All of those things are things that you should be talking about. Next is getting organized. So you want to empower your agents with information, keeping good records, helping them access what they need by having your legal and financial house in order. And this doesn't mean keeping every receipt and every piece of paper, because quite honestly, having every little piece of paper honestly usually makes it worse. But keeping what's important, making sure they know what they need, where it is, how to get to it, if there's password protected, that they know how to gain access. And that's being well organized and well documented is really a gift to your agents. And then consider the future. What do you want for your aging years? What if your plan goes awry? What are you willing and not willing to compromise? And I know ideally most people want to stay in their home and age in place. I used to own a home care company, so I know that that's a primary goal for a lot of people. But what if it becomes impossible? What if other scenarios, what would you consider acceptable if other scenarios arise? And who will help you make those decisions? And can you make some of those decisions in advance? And then putting together a support team. This means key personal and professional supports. And I'm only going to mention this now because I'm going to come back to it later in more detail, but it certainly is another way to plan well. And then maintaining your plan. So I mentioned earlier, proactive planning is more than simply drafting documents. Once you have your plan in place, it's important to maintain it. And so as your life, relationships, situation, and assets change, your plan may need to be updated. And one key factor here is with your assets, making sure that the will and the trust and the beneficiary designations, that all of those tools that transfer assets are working together and not against each other. And that can easily get out of control without regular maintenance of your plan and working together with the different professionals that all have a piece of this responsibility. And Shea and I were talking this morning and kind of decided on the fly to add in some examples of where we've seen some of this and experienced this as members of Planning for Senior Life. So I'm going to flip it back to her to talk a little bit about those case studies.
Yeah, so one example that we've seen is we had an elderly woman who had an account somewhere and she needed to move it over. Well, she was in and out of the hospital, and her daughter, who's her power of attorney, had to take over and start helping with things. So she needed to move the account. Well, this particular account was an individual account with beneficiaries called a transfer on death. So as we're doing the paperwork, putting in the transfer, everything, we get a notice from the custodian saying, hey, this power of attorney actually doesn't allow for the agent to name beneficiaries. So at that point, because this person's health, wasn't the best, she was in and out of the hospital, we didn't want to move anything, we didn't want to touch anything because anything could happen, and we didn't want to not have beneficiaries. So this is an example where, I can reach out to Pam and be like, hey, this is a situation, what can we do to fix this? And another example is with the maintenance. So one thing we do each year, annual reviews, and we look at everything. So, it's not just your financial assets, it's also your estate planning documents. And we, say, hey, this is who you've got named, is this still how you want it to be? And I had a couple one time, they didn't have any children, and we were going through their agents that they'd named, and they realized, they were like, wait a second, hold on, this person got into some trouble and we don't think he's a good person anymore to be handling our situation, once we pass. So we need to get that fixed immediately. And so another example where we can reach out, get a meeting on the calendar with Pam and say, hey, can you help us fix this? So maintenance is crucial.
Yeah, and those are some really good examples as we were brainstorming this morning, just a couple of many situations that we've experienced and that other members of Planning for Senior Life have experienced. But I think we honed in on these two because it's so important, so crucial to think about the importance of that support system. And so I touched on this earlier, and I'm going to elaborate a little bit now. We're talking about these key relationships, and they are both professional and personal. As I was describing to you the importance of the financial agent and the medical agent earlier, you have to have those people in place in your life that are going to step up and be advocates for you and help you through difficult situations. But they don't know it all. They are presumably not professionals in these various fields, and even if they are, I've been there. I know what it's like to have a healthcare crisis situation with a loved one, and I'm in this field. And when it hits you as a individual and it hits your own family, it's overwhelming. It's a shock, and so it's not the easiest thing to manage. So we suggest, and this is a kind of a driving point behind Planning for Senior Life, to have a team, to have support persons in place from these different professional areas to help support those agents. And so you're going to want to have, legal professionals, financial professionals like Shea, care professionals, care managers, your healthcare professionals, all working together, at least have each other's contact information, kind of know the key professionals that you're working with, know your agents. The better you can kind of create this community ahead of time, the smoother these situations will go when they hit. And we can't avoid the crisis completely, but we certainly can, we can have a much greater impact to steer things back in a positive manner when we do have this support network in place and everybody's communicating and everybody knows what we're doing. So why this collaborative approach works well from our perspective is that, well, a number of things, abuse, exploitation, financial abuse. These aren't nice, pleasant things to think about, but abuse happens most frequently when one person has the keys to the kingdom. So when you trust one person solely with everything, it gives a lot of room for error and for misgiving behavior. So it is good to have that check and balance, to have people who are looking out for you and watching everyone else. So it gives you that sense of security there. Also, if someone isn't doing their part, if a member of the team, whether it be your agent or one of the professionals, isn't doing what they're supposed to be doing, or isn't following ethical guidelines, or isn't living up to their professional standards, the rest of the team can come together and bring this to your agent's attention or to your attention and say, hey, this isn't working. Maybe we need to think about bringing somebody else in to manage the investments or to handle the legal documents and things like that. So it gives you, again, that's still a check. It still falls kind of in the check and balance category of making sure that everybody's living up to their professional standards. And then finally, easing burden on your loved ones. And I'll just drive this home just a little bit more because it's so important when someone is thrown into this situation. It is not easy. Presumably, they are a loved one of yours. They care about you. They're stressed out that you are in an incapacitated situation. Maybe your health is at risk. They don't know what's going to happen. So right now, they are most concerned about taking care of you and being your family member and being there for you emotionally. So they shouldn't have to bear all the burden of the legal, financial, and care decisions. They should have a support network that can help guide them in making those decisions and ease that burden when they're in that situation. So you're really just giving your loved ones and your agents a gift of alleviating some of that stress and allowing them to make those decisions much easier. So that's why we feel that you're preserving your independence through these interdependent relationships, making your wishes known ahead of time, ensuring that everybody's on the same page, and then counting on these key relationships to carry them out to the best of their abilities and to the way that you would have wanted them to be. So with that, we wrap up. And unless I missed anything, Shea, I think we'll be ready to take some questions.
Yeah, and well, one thing I did want to point out is, we do have all these professionals within our Planning for Senior Life group. So if there's anything that you guys want from an educational perspective, from those 5 pillars, please reach out to us and let us know, because that's what we're trying to do. We're trying to, educate the public, on all of these areas of planning for senior life. And our contact information is there, so please, don't hesitate to reach out.
Thank you both so much for that really useful information. If anyone has any questions, please type them in the chat box and I'll be happy to relay them to Pam and Shea. The one question we have already is somebody read, they don't have all the details, something about in Virginia, they will let you deduct from your income after a certain age. Is that only if you're retired?
What do you mean deduct?
Deduct from your, so I think it was, I think I know what this person is talking about because I think I read it too, but you're able to, for your taxes, deduct like 10 to 20,000 off of your annual income for tax purposes after a certain age.
Do you mean gifting? Do you mean?
No, it's not gifting.
Okay.
I am not
You've heard of
sure.
that? Okay. All
Yeah,
right.
what comes to mind for me is the 15,000 a year for, gift tax exemption, but I'm not sure if that's what they're getting at. But
I'm gonna
Yeah,
try
and
and
I don't prepare taxes, so I'm not.
Right, yeah. Okay, so if you were born on or before January 1st, 1956, you may qualify to claim an age deduction of up to 12,000 each.
Okay.
All right. Anyway, so another question. I just lost my mom and am the executor and overwhelmed. Any tips, and also how to prepare so I don't leave things in disarray for my daughter when I die?
yeah, that's unfortunately, I see this a lot every week. We're walking with people through this situation, and I really don't think you have any idea how difficult it's going to be until you're thrown into it. But as far as tips, unfortunately, if you're dealing with a messy probate situation, it's very hard. And the pre-planning is so important. So if it's a mess, it's very hard to do anything after the fact. If there's assets, if the estate can afford it, hire an attorney. Reach out to a probate estate attorney and ask them for help. There are some crucial deadlines, and it's very important to get your documentation right. And hiring an attorney that does this every week can certainly help you through that. And those expenses, those are reasonable expenses that are paid by the estate. So if there are assets there, it means the beneficiaries get a little bit less, but you are the executor and you do have the right to do that. As far as looking to the future and how to make it easier for your loved ones going forward, that really depends on your situation, your asset structure, your goals. But there certainly are ways. There are ways to make probate easier. If you just have a will, a well-drafted will with a little bit of extra work on your part, can make probate a lot easier for your loved ones. And a good estate attorney can walk you through what those different ways of doing that are. And then there's also some other tools. So you can use, as I mentioned before, you can use trusts. You can work with your financial advisor and your attorney to set up your beneficiary designations well. So there are some different things that you can do depending on the types of assets that you have to make it much easier on your loved ones when you pass away. So I would recommend, again, talking to a probate and estate attorney about that and your individual situation to see what makes the most sense for you.
A follow-up to that question, are there any crucial deadlines worth mentioning? And is a trust better than other choices? I know that's a really big question. That second one, we could have a program all about wills versus trusts.
Yeah.
But how about the crucial deadlines?
There are, yes. And I'm not the professional in that area. We have a team of paralegals that handle the probate, but there are, much like Shea was talking about the deadlines that are important not to miss with Medicare and Social Security. There are deadlines when it comes to probate and, submitting filings to the court. So that is important. You can get extensions. So they're not necessarily hard deadlines, but yes, there are. Once you get qualified as the executor, they'll give you all of that information. So if you're not qualified yet, you will be getting an awful lot of information once you go through that process. And then you can, as I mentioned, you can certainly work with a probate attorney to help you make sure that you're preparing for those deadlines and that you get what you need into the court timely. To the second question, Lorraine is absolutely right. That's a very complicated area. The short answer is there's no right or wrong way. It's very personalized. Trusts do avoid probate. You can do a revocable trust as a probate avoidance trust, which just means that it doesn't go through probate. It gets a direct transfer of your assets to your beneficiaries. It's the same job. The executor and the trustee, they still have to gather your assets and then distribute them according to the instructions that are in your trust. They just don't have to do it under the purview of the court and do those filings and meet the deadlines that we were talking about. So it's a less stressful situation doing it that way. And whether a trust makes sense for you kind of depends on the types of assets you have and ownership of those assets. And sometimes people have other goals they're trying to accomplish with trusts, like, Medicaid planning, asset protection, things like that. So again, there's a lot of different types of trusts. So depending on your personal situation, whether a trust would accomplish your goals or not, would be an individual discussion with an attorney.
Okay. So can you earn unlimited compensation after full retirement age and still collect Social Security?
Yes. As long as you're full retirement age, you can earn as much as you want.
And collect Social Security at the same time?
Yep.
Okay. And full retirement age is 67, right?
Full retirement age is age 66 if you were born 1954 or before, and it's age 67 at 1960. And in between there, it jumps 2 months. So 66 and 2 months, 66 and 4 months, 6
Okay.
10.
So, all right. What is the penalty for earning compensation before reaching full Social Security age?
So there is a dollar limit. I think it's roughly about 18,000 this year. If you're earning wage income or self-employment, that once you reach that dollar limit, then they start, it's almost like a 2-for-1. I don't know the exact formula off the top of my head, but that's when they start claiming some back after the around 18,000 per year, which is indexed for inflation each year.
Okay. Boy, there's a lot of rules.
There are.
Hold on a second. Is the estate state laws different in different states?
Yes. Yes, everything we talked about today in terms of legal planning is state specific, yes.
Okay. This person writes, if we had a revocable living trust drafted for real estate back in January 2015, do we need to have a more up-to-date version?
It depends. Depends on what may have changed in your life and situation and what you're trying to accomplish now versus then. There isn't anything necessarily. It's not like they don't really expire per se. They do get out of date. And so I would say the best thing to do if you have a question about it is just have them reviewed and make sure that what you're trying to accomplish is still would be accomplished based on the language that's being used in your trust. And I go back to the point in the presentation about the maintenance. It's not necessarily redoing the documents on any certain regular basis, but it's more of making sure that the assets that you have are in the trust and titled appropriately and the beneficiary designations are correct. And so that's one of the problems we see with people setting up trusts is that they kind of forget that they did it or that it's not top of mind. And so as they buy and change assets and move and do different things with life, they forget to make sure things are titled into the trust. So I mentioned that because if it was in 2015, 6 years have gone by. And so if you've bought and sold things and moved around and acquired new assets and things like that, it's probably a good time to review that part of it, not necessarily redo the documents, but make sure that everything is titled and works correctly with your trust.
Okay. Someone else writes, if one of our children has had addiction problems and we want to ensure that they don't receive a large inheritance from our estate, is that easy or possible to do? Is it possible to add conditions like drug tests or something else so that they could someday have access to their inheritance? And how would we structure something like that?
Yes, the answer to all of the above is yes, you can do that. It's one of the nice things about trust is that you can really put any instructions or requirements in it that you would like to the extent that they can be executed. The more specific you get might make it a little more difficult, but you can absolutely put restrictions. A lot of people do ages. Sometimes it's landmarks, different accomplishments in life. Sometimes it's putting restrictions on what the money can be used for versus when they can get it. So there's a number of different options, but the short answer is yes. And a lot of times people think of what you're talking about as a minor's trust or an underage trust. And it's kind of a misnomer because you can do these things for your children or other beneficiaries, regardless of whether they're over the age of 18. It just tends to be most people set them up when their children are minors, but you can make those restrictions and those limitations on it. Honestly, as long as to whatever point that you're comfortable, you can do that. Some people even set up trust where the beneficiary can't access it until retirement. So there's any number of options there, but the short answer is yes, you can do all of those things.
Okay. This is from the person who suddenly finds him an executor of his mother's will. How do you find out what your deceased mother's assets are?
Yeah, that's a tough one. And that's one of again, I go back to the tips on making things easier for your loved ones and staying organized. you have to dig and you have to research, and it's not always the easiest thing, but you know, you're gonna have to go through paperwork. You're gonna have to contact financial institutions that you know she was working with. Hopefully she does have bankers and or financial advisors that you can, you know, or CPA or someone, you know, hopefully you can track down professionals that she may have been working with at some point through paperwork, and make phone calls and gather the information. If she didn't keep it organized and keep it in a place that's easy for you, it's investigation. So if kind of going back to the earlier question about are there deadlines and how does this work, you know, going to the court and explaining that the situation that you're in and asking for extensions is certainly something that you can and should do if you find yourself in that situation. But I wish I had a better answer for you, but it's going to be a tough road of doing research and making a lot of phone calls.
Pam, is there
I
a
would
nonprofit?
also,
Is there a nonprofit that can help someone if they can't afford a lawyer, or, you know, to give some?
There are some. I'm not really that well versed in that, but yes, I believe they're like Loudoun County, I think, does have a legal services not nonprofit. So yes, I believe there are, but I don't have a list, you know, or direct information for you at the moment. But yes, I believe that there are.
Okay, and I'm sorry to interrupt you, Shea.
that's okay. I was just also going to add, check the state's unclaimed property site too, because
Oh,
there's
right.
a
Yeah.
lot of people that find assets on there as well.
Good tip. I found something for myself a couple of years ago. I was surprised.
Cool. Um, if the power of attorney and some other documents are executed in one state, are they valid in another state then?
Technically, yes, for most states. The challenge comes in with actually using them. So the practical application, because they are state specific, the institutions, the medical community, the financial community, they're used to saying what's specific to their state. So you can run into problems using them when the doctor or the banker that you are dealing with doesn't know what they're looking at and then has to run it up the chain and get their legal departments to review it and things like that. So they're valid, but it may, if you have the opportunity to update them once you have moved, if the person still has capacity, it is a good idea to do it because it will make things much easier to have state specific ones.
So the person who asked the question earlier about, John, let me just get to it. If we had a revocable living trust drafted for real estate back in January 2015, do we need to have a more up-to-date version? She mentioned she's asking that question because there was a change in the law on trusts after January 2015.
Yeah, there are changes in the law on a regular basis. So whether they would apply specifically to you and your trust and your scenario, I can't really speak to that. But that is one of the things, you know, major changes in your life, your situation and your asset structure, and then regular changes in the law do create the need to make sure that your documents are reviewed and that you are maintaining it on a regular basis. So yes, having them looked at to be sure they're still meeting your goals would certainly be a good idea.
Okay. Are the advanced healthcare directive forms published by the VA Hospital Association good enough? The Virginia Hospital Association, I guess.
Yes and no. Those are honestly one of the documents that we've seen the most difficulty with implementing. The way that they are written and the way that they are executed, they are valid and legal, but we get quite a few clients that come to us that have those and are having trouble using them and implementing them, and so then they come to us to get the standard Virginia documents done that meet the requirements. So Yes, they're valid. They're just, I go back to the comment earlier about the practical implication outside of that organization and health system. They can be much harder to implement.
How do you know if you're choosing a lawyer who's using the best, you're talking about this form here that's had problems. How do you know when you choose a lawyer that they're using the best forms and giving you the best advice? I mean, other
Sure.
than Googling and seeing reviews, I mean,
Yeah.
you can't really trust those.
Yeah, it is tough. I would say when you're interviewing them, and you always should interview them, find out about their background. What have they done in their career? For me, working with Josh, I know that he's for almost 10 years, he did litigation of wills and trusts and these types of documents. So we saw a lot of what could go wrong. And that's why we do what we do today to help people avoid a lot of those problems. And pitfalls. The other thing I'll say is that a lot of people do their wills and documents online through LegalZoom or other avenues, and there's a lot of problems with that. But a lot of attorneys do the same thing. They just subscribe to document preparation tools, and they're just kind of cookie cutter. So asking, and to the extent that you believe their response, if they just use a document preparation tool or if they draft their documents per client, is another way to know whether they're really doing things the right way. But otherwise, you're right. It's very difficult. Reading reviews online is great. To the extent that you can get a personal referral, that's wonderful. If you can use a referral service like the bar referral service or something like Planning for Senior Life where they've been vetted, that's very helpful as well.
Okay. Any other questions?
Great questions.
Yeah. Okay, Shea and Pam, is there anything else you'd like to add before we close the program?
Yeah, I mean, like I said before, I think if you have any specific topics that you want to hear, reach out to us and let us know. You can find Planning for Senior Life on our website, and we also have a Facebook page. Go there, comment, let us know what you want to hear so that we can, get more of these presentations out there.
Yeah, we do plan to share the recorded version on our Facebook page. And also we did put together a handout with kind of a summary of this information that'll be available through Planning for Senior Life, and feel free to reach out to myself or Shea if you'd like us to send you a copy of that.
Well, and the Facebook page that you're referring to, do you have that up there on the screen? I don't see it. I'll type it in the chat if you tell me what the...
Yeah, let me make sure I got the right one.
And also to you, everyone, the recording will also be on the Loudoun County Public Library YouTube page.
Okay, so it is just, let's see. Sorry. Okay, so it's just facebook.com/planning for senior life. And then it's a backslash after life.
Okay. So there's the address, everyone. Well, thank you, Shea and Pam. Thank you so much. This is complicated. I don't want to stress everyone out, but it's complicated to navigate through all this. And you are so right. The better planned you are, the easier it's going to be. And I think too, it lessens your anxiety about the future, doesn't it? If you know that everything is in place, right? You don't have to sweat it so much anymore.
Right.
So, yeah.
Yeah, the sense of relief we see on our clients once they've gotten this done is, yeah, it's immense.
Oh, yeah, absolutely. All right, well, thank you all for attending. I will type my email here, and if there's something more you'd like to hear about, maybe like to ask Pam and Shea back for more in-depth information, just send me an email and let me know, and I'll reach out to them and see if they're willing to do something else for us. Thank you.
Thank you.
Thanks for having us. Have a good night.